Good evening, everyone. Welcome to the third class of PYQ matrix. This is third class of the subject of polity. In the last two classes, I have discussed the 2025 and the 2024 question paper of UPSC CSE Prelims. In this class, I will be discussing the 2023 Prelims question paper of UPSC. So let us right away dive into the questions. So the first question for today, in essence, what does the term due process of law mean? A very common question in the UPSC circles, the due process of law. So what does this term actually mean? So this was a pretty tricky question in the 2023 prelims. First option, the principles of natural justice, procedure established by law, fair application of law, and equality before law. So all the options appear to be very confusing in nature. So how do we decide upon what does the term due process of law actually mean? Now, what we can do is we can start eliminating what is actually not the option. So that's a better way to approach this question. So the term is due process of law. What does that mean? The due process of law means the law has to be fair, just, and reasonable. The law has to be fair, just, and reasonable. That is the meaning of the term due process of law. So the first one that we can eliminate here is equality before the law. So equality before the law is given under Article 14, but is that something called as due process of law? No, we can eliminate D easily. Now, can we say fair application of law? Since they are also using the term fair here, so let us park it aside. We can think about this. B, the procedure established by law. So does the due process of law and procedure established by law same? No, we have read that in our Lakshmikant polity. So Article 21 of the Constitution of India talks about the procedure established by law. And this has been established through the Shankari Prasad case, the A.K. Gopalan case, etc., that Indian Constitution has the procedure established by law. And later in the Maneka Gandhi case, 1980, the Supreme Court also held that the term procedure established by law in Article number 21 also means due process of law. So that means to say that the judicial review as given in Article 13 of the Constitution of India does give the right to the Supreme Court and High Court to actually go and check whether the law is just, fair, and reasonable, and not just check the procedure established by law, not just checking the procedure through which the law has gone through. Okay, they can actually check the fairness of the law. So does procedure established by law and due process of law mean the same? No, obviously no. So 2 we have eliminated. Now it comes to the 50-50 chance where principle of natural justice and fair application of law is there. So here let us go deeper now. Why is this wrong? Fair application of law. Because what does the due process of law mean? Fair, just, and reasonable laws. It is not just application of the law, but the law in itself need to be fair. It's not just a fair application of the law. The law itself needs to be fair, just, and reasonable. Hence, we can say application of law is just one part of it. So we can say that this is not exactly what does the term due process of law means. So we can go ahead with one, the principles of natural justice as the answer here. Sometimes what happens, the elimination technique works, and elimination technique it's not like 1 and 2 only, 1 and 3 only, that elimination technique is gone, but elimination through some logical conclusions, that is what is called as elimination today. And this question is a very clear-cut example of how elimination technique can actually be used. Okay, yeah, welcome to the class, those people who are online. Aishwarya, Vinit, Kumar, Sushma ji, yes, all of you, welcome to the class. Next question. Now, in this slide, I've also written down what does the component of the natural justice actually mean. So it has three components. One, rule against bias. That means you cannot be a judge in your own case. Second one, right to fair hearing. That means no party has to be condemned unheard. So if somebody has done a wrong thing, you cannot just dismiss him saying that, oh, he has done a wrong thing. You need to give him a fair trial. You need to give him a fair hearing. Only then you can condemn him. Okay. Then the third one, speaking orders. That means to say, if you are declaring somebody guilty, you are saying that, okay, this person has done the wrong thing. You need to also write down why did you actually come to this conclusion, on what basis did you come to this conclusion, and why do you think that person is guilty. That is basically what does the term speaking orders means. So principles of natural justice has appeared in the UPSC Prelims quite a large number of times. So this is what is principles of natural justice mean. If you want to remember, you can remember even the Latin names of it also. So nemo, judex, in causa, audi, alterum, partem, etc. So this is what does natural justice actually mean. Then the next question. Consider the following statements. Statement 1. In India, prisons are managed by the state governments with their own rules and regulations for the day-to-day administration of the prisons. Statement 2. In India, prisons are governed by the Prisons Act 1894, which expressly kept the subject of prisons in the control of provincial governments, a British era law. Which one of the following statements in respect of the above are correct? So they're asking for correct statement from the above. So first statement, it's about prisons. So in which list is the prisons? 7th schedule. 7वीं अनुसूची में we have 3 lists: union list, state list, and concurrent list. In which list does the prisons come in? The prisons are there in the state list. The prisons are there in the state list. So since they are in the state list, so it is managed by the state governments with their own rules and regulations for the day-to-day administration of the prisons. And even when you are writing your PCS exams, provincial civil services exam, there will be a post of DYSP prisons in this. So since they are recruiting it, we can clearly understand that it comes under the state government and they will look at the day-to-day prisons operations. So first statement is correct. So there was a news during this time that there has been alleged mismanagement in the prisons, that the prisoners are getting a lot of, say, facilities inside the prison that they should not get in general. So that is why this question has actually come in UPSC. Statement 2, in India, prisons are governed by the Prisons Act 1894. Absolutely correct. After that, there has been no act related to the prisons. So modern Prisons Act are expected, which expressly kept the subject of prisons in the control of provincial governments. Correct. So both the statements given above are correct. So both statement 1 and statement 2 are correct, and statement 2 is the correct explanation of the statement 1. That is absolutely correct. So A is the answer here. So all of you can be giving your answers. Please put it in the comment section. So which one of the following statements best reflects the chief purpose of a constitution of a country? So constitution and constitutionalism, they have been asked in the UPSC prelims a large number of times. So these questions have been picked up from the NCERT, Constitution at Work, Political Theory, 11th Standard NCERTs. So they are asking, what does Constitution actually do? Which one of the following statements best reflects the chief purpose of the Constitution? So it determines the objective for making of necessary laws. Yes, the laws which have been made by the Parliament definitely needs to keep in mind the objectives of the Constitution also. So objectives of the law need to align with the objectives of the Constitution, no doubt about it. But is that the principle why Constitution is actually present? No. It enables the creation of political offices and a government. Yes, definitely. All of these political offices and government, your PM, your CM, your governor, president, everybody derives their power from the constitution of the country. But does it mean that it is a principle or the chief purpose of it? No. It defines and limits the powers of the government. Yes, it does. It secures social justice and social equality and social security. Some constitutions might, some constitutions might not. So this is wrong. So what is left here? It defines and limits the powers of the government. So we have heard a large number of times that the government have a limited power, and those powers are limited by the constitution of the country. So constitution defines the framework in which the judiciary, the executive and the political offices, the legislature must actually work. So it defines and limits the powers of the government. Here they are talking about the executive. So is that the chief purpose? Yes. C is the right answer here. Okay. You guys are getting it. If there are any doubts, please put it on the comment section so that I can clarify. Okay. Minimum government, maximum governance. Yes, absolutely correct. Consider the following organizations or bodies in India: the National Commission for Backward Classes, National Human Rights Commission, Law Commission, National Consumer Dispute Redressal Commission. Which of the above are constitutional bodies? So a fairly easy question after some 2 to 3 very tricky question. UPSC has given a fairly easy question. This is a very straightforward one. National Commission for Backward Classes, created very recently. So we have the article number 338. So 338 has the National Commission for SC. 338A has the National Commission for ST, and 338B has the National Commission for the Scheduled Tribe. So is that a constitutional body? Yes, currently. National Human Rights Commission, is it a constitutional body? No. We have the Protection of Human Rights Act 1993. So we had the Paris Principles, which spoke about the protection of human rights in the country. It was adopted in 1991, and later the Protection of Human Rights Act 1993 came into picture in India, and based on that we created 2 Human Rights Commission, one at the national level, the National Human Rights Commission, and other is at the state level, the State Human Rights Commission. So are they constitutional bodies? No, they are statutory bodies. So statement number 2 here is wrong. It's not a constitutional body. National Law Commission, is that a constitutional body? No. So Law Commission, you know that the first Law Commission was created in 1834. Lord Macaulay was the chairman of this commission, and national commissions are created by the President of India. Whenever there is a need, say for example, they want to go for any legal reforms in the country, that means they want to do away a certain set of laws, they want the Law Commission to look into like bringing a new law or suggest the government to change the existing laws, or even on the reference by the Supreme Court and the High Court, the Law Commission of India can actually be set up. So recent Law Commission has been set up, the time period being 2024 to 2027. So they are looking into a set of laws now. So National Law Commission, is it a constitutional body? No. Is it a statutory body? No. Then this is also wrong option. National Consumer Dispute Redressal Commission, is that a constitutional body? No. Because in the 1986, we had the Consumer Disputes Redressal Act. Based on that, in 1988, we created this body. So this is basically a commission which looks at the consumer disputes. Okay. So this is definitely, this is a statutory body and definitely not a constitutional body. So this is also wrong. So how many of them are constitutional bodies? Only one. A is the correct answer here. Please note. Okay. Good evening, Game Changer. Good evening, Abhimanyu. Yes, good evening, Harish. Then next question. Consider the following statements. If the election of the President of India is declared void by the Supreme Court of India, all the acts done by him or her in the performance of duties of his or her office of the president before the date of the decision becomes invalid. That means somebody has been elected as the president and that election has been declared as void. So can the Supreme Court of India declare the election of the president void? Yes, only the Supreme Court of India has the original jurisdiction. It is only the Supreme Court of India which has the original jurisdiction to look into the election disputes of the President of India and the Vice President of India. So can they look into it? Yes. Can they declare it as void? Yes. So first part of this statement is correct. Second part of it, all acts done by him in the performance of his duties of his or her office of the president before the date of decision become invalid. Is it a right one? No. If that person is acting as the president of India and he has done certain say work, now election has been declared as void. Whatever the decision taken by him previous to this, his election going void, actually stands valid. Actually stands valid. So first statement here is wrong. Election for the post of the President of India can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. So who conducts the election to the post of the President of India? It's the Election Commission of India. Now, any election to the post of the President must be conducted within 6 months of the expiry of the term of the President. Generally, whenever there is a sitting President, they will conduct the elections. And while they are conducting elections, if, say, for example, some legislative assemblies have been dissolved, because legislative assembly they know the duration of the legislative assembly is also 5 years only, right? So imagine some 4 to 5 states का legislative assembly dissolve हुआ है, तब can the EIC, Election Commission of India, say that I'm going to postpone the presidential election because that electoral college that we are trying to set up? What does the electoral college consist of? It consists of the elected MPs of Lok Sabha and Rajya Sabha. It also consists of elected MLAs of state legislative assemblies. Now, because in this part, the elected MLAs of state legislative assemblies, some of the states are not able to take part because they have been dissolved. Now, is that something or becomes a reason for the postponement? No. Statement 2 is also wrong. When a bill is presented to the President of India, the Constitution prescribes time limits within which he or she has to declare his or her assent. Is that right? No. Because he has what is called as pocket veto. What does the pocket veto mean? It means that whenever there is a bill presented to the President of India after being duly passed by Lok Sabha and the Rajya Sabha, there is no time limit mentioned in the Constitution of India as to when the President has to assent to the bill. So the third statement saying that there is a time limit for it is wrong. And recently, we have seen a very great controversy in the case of government of Tamil Nadu versus the governor of Tamil Nadu, where the Supreme Court tried to fix a certain number of days. Say, for example, the president has to, either sign the bill or say withhold it within 3 months. So that became a real controversy. And again, the same type of question has been asked in 2023 itself. Okay. So the timeline here definitely is wrong. So 1, 2, 3, all of them are wrong, and they're asking for the correct statement. None of them are actually correct. D, none becomes the answer. All of you are getting it? RN Ravi case. Yes, game changer, correct. It's RN Ravi case. Then, with reference to finance bill and the money bill in the Indian Parliament, consider the following statement. So finance bill and money bill are recurring topics in UPSC. You need to look at it, okay, all the time. When the Lok Sabha transmits finance bill to the Rajya Sabha, it can amend or reject the bill. When the Lok Sabha transmits a finance bill, so when it comes to finance bill, there are three types of finance bills: financial bill type 1, financial bill type 2, and money bill. So even if we consider money bill separately, let us park this statement. When the Lok Sabha transmits money bill to the Rajya Sabha, when the Lok Sabha transmits money bill to the Rajya Sabha, it cannot amend or reject the bill. So yesterday in my class, I have dealt in detail regarding the procedure for, the passage of the money bill between when it changes from Lok Sabha to the Rajya Sabha. So it cannot amend or reject the bill. It can only make recommendation. That's a right statement. The money bill with the Rajya Sabha with respect to money bill does not have much powers. Either they can recommend or they can actually accept it. No other options are allowed for them. So can they amend or reject? No. In the case of disagreement between the Lok Sabha and the Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for finance bill. So, what in case of disagreement between the Lok Sabha and the Rajya Sabha, the situation is considered as a situation of deadlock. On a certain point, the Lok Sabha and the Rajya Sabha are differing from each other. Lok Sabha and Rajya Sabha, that's a deadlock. There is no joint sitting for the case of a money bill. Yes, because yesterday itself I told you that if the recommendations made by the Lok Sabha Rajya Sabha to the Lok Sabha for amending the bill are not accepted by the Lok Sabha, then the bill is deemed to have been passed. Or if the Rajya Sabha delays the bill by not passing it for the next 14 days, then also it is deemed to have been passed. So Rajya Sabha is not very powerful in this case. So can they go for a joint sitting here? No, definitely no. And it becomes necessary for a finance bill. So is it allowed in the case of finance bill? Yes. Financial bills are equivalent to ordinary bills. Only difference is financial bill 1 can be introduced only on the recommendation, only in the Lok Sabha, and financial bill 2, the presidential not prior recommendation, but presidential recommendation is actually necessary. So is the joint sitting allowed in the case of finance bill? Yes, because it behaves like an ordinary bill. Then how many of the above statements are correct? So 3 is definitely correct, 2 is definitely correct. When the Lok Sabha transmit finance bill to the Rajya Sabha, it can amend or reject the bill. Yes, it can amend, it can also reject the bill if it's a finance bill. But if you go with a very strict knowledge of the finance bills can be of 3 types. The one money bill can also be called as a finance bill. So if you go with a very strict sense, then the statement 1 becomes wrong. If you go with a very general sense that we are considering only FB1 and FB2, that is Article 117.1 and Article 117.3, then the statement 1 also becomes true. So how many of them are correct? All the 3 here are correct. Okay. So in some books, they have given it as only 2 are correct. Okay. With reference to the scheduled areas, are you guys getting it? No joint sitting for the money bill. Yes, correct. Abhimanyu, correct. Game changer, correct. With reference to scheduled areas in India, see once again, question on scheduled areas. Yesterday we have solved 2 papers. In those 2 papers, we had scheduled areas and tribal areas. Again, obsession of UPSC with the scheduled areas continues. With reference to scheduled areas in India, consider the following statements. Within a state, the notification of an area as a scheduled area takes place by an order of the President of India. So yesterday itself I have declared this, saying that the declaration of an area as a scheduled area in a state is done by the President of India, correct? The largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of villages in the block. So can we declare a certain group of villages as a scheduled area in a certain state? Yes, it is possible. So statement 2 also becomes correct. Statement 1 is correct, statement 2 is correct. Let us see the statement 3. The chief ministers of the concerned states are required to submit annual report to the Union Home Ministry on the administration of scheduled areas in the states. So there is a necessity of the report, no doubt about it. But the report has to be given by the governor to the President of India. Okay, so report has to be given by the governor to the President of India, telling them or informing the central government about how the scheduled area is actually doing. Why have we declared this as a scheduled area? Because this has been a backward area. There are a lot of tribals in it and we want them to actually improve. Now, the president will receive information from the governor saying that the improvement has come in or improvement has not come in. These are the roadblocks, etc. So that report has to go there. So whether the CM is sending the report here? No. So how many statements of the above statement are correct? Only 2 are correct. Okay. So B is the answer here, not the CM, the governor. Yes, Vinit Kumar, correct. Then the next question. Consider the following statement. Statement 1. The Supreme Court of India has held in some judgments that the reservation policies made under the article number 16(4) of the Constitution of India would be limited by Article 335 for maintenance of efficiency in administration. So we have two articles here. One is article number 16 and in that subclause 4. What is article 16? 16 is about provision of equal opportunity for employment for all the sections of society. But certain positive discrimination can be made, certain affirmative actions can be taken in the name of, say, women, children, and the weaker section, that are scheduled tribe, OBC, transgenders also. So, under article number 16(4), have we introduced reservation for the scheduled castes and scheduled tribes? Yes, we have done it. And recently 16(6) is also been added in the favor of the EWS reservation. Now, that reservation has been provided with the intention to increase the number of scheduled caste, scheduled tribe candidate in the bureaucracy, no doubt about that. But it should also not lead to inefficiency in administration. So, which case said that? It is a Nagaraj case which spoke about the OBC reservation issue. Okay, so after the Indra Sawhney case, the main case regarding the OBCs were the Nagaraj case 2025. They also said that yes, reservation or positive discrimination can be done, but it should not lead to inefficiency in terms of administration. That is again repeated by the Supreme Court of India in quite a huge number of cases. That's exactly what the statement is trying to tell you. So statement number 1 is correct. Statement number 2 ka Article 335 of the Constitution of India defines the term efficiency of administration. Again, be very, very clear about certain definitions, because this line of questioning by UPSC has been quite repetitive. One is they will ask whether the Constitution has defined it, or they will say that this word has been mentioned in the Constitution. These are two very repetitive themes in the UPSC question paper. One, they will say that the Constitution has defined this word, saying that defection has been defined, the breakdown of constitutional machinery has been defined, or here the efficiency of administration has been defined. Now, always understand, efficiency of administration is a very subjective term. Now, anything that is extra subjective definitely cannot be defined in the Constitution itself. Some things, yes, they have defined it, but a lot of things have not been defined. It has been left to the Parliament of India. So here, have they defined this efficiency of administration? Definitely no. Okay. Or they might use the word saying that the word efficiency of administration is used in the Constitution of India in the article number 335. Then at that point of time, yes, it becomes correct. So here the statement 1 is correct, statement 2 is wrong. So which of the following option is correct? The third one. Statement 1 is correct, but statement 2 is incorrect. Are you able to understand? Are you able to understand this? What are the type of questions which have been asked? These are very typical UPSC questions. That is exactly where most of the students get stumbled. Okay. Next question. According to the Constitution of India, the central government has a duty to protect states from internal disturbances. So again, this is a very simple and a similar question. According to Constitution of India, the central government has a duty to protect state from internal disturbances. This is under Article 355 of the Constitution of India. Yesterday we were speaking about the national emergency. So those people who have not seen the previous videos, the 2025 question paper, 24 question paper, please see those videos also. This is Article 355. What does Article 355 say? 355 says that the central government has to make sure that the government in the state is carried on in accordance with the provisions of the Constitution of India. And it also says that it is the duty of the central government to protect any state in this country from any external aggression or internal disturbance. I repeat, it is the duty of the central government to protect any state in this country from any external aggression and internal disturbance. That is why if there is an attack by Pakistan on Jammu and Kashmir, the Indian government cannot say that अरे ये तो अटैक स्टेट पे हुआ है and we cannot do anything about it. So they cannot say that because Article 355. And if there are some Naxalites operating inside the state, they cannot say that since law and order is actually in the state list, वो तो उनका headache है. So they cannot actually say that. It is their responsibility to make sure that there is no internal disturbances inside the state. So this is directly taken from Article 355 of the Constitution. So statement 1 is correct here. The Constitution of India exempts the state from providing legal counsel to a person being held under preventive detention. So these are certain very controversial aspects of the Constitution of India. The preventive detention laws are under Article 22. Article 22 talks about two different types of detentions. One is the preventive, other is the punitive. Preventive means you take a person into custody before he conducts any crime. Now the Constitution of India, does it exempt the state from providing legal counsel? See, the point here is when we look at punitive detention, that means if somebody has been held on the orders of the court, he has done a certain mistake, the court has given the police custody of that person, or if the police under a certain suspicion have arrested that person, then that is punitive detention. Under punitive detention, what are the protections guaranteed by the Constitution? The person has to be informed of the grounds of arrest. मतलब arrest क्यों किया है? On what grounds the person has been arrested? That has to be communicated to him. Not only this, he has to be given a legal counsel. That means अगर वो lawyer के साथ समालोचन करना चाहता है, तो we need to allow that to happen. Then he has to be brought before the magistrate within 24 hours of his arrest, except the travel time. Then, if the magistrate does not authorize further detention, then that person needs to be released from the prison. So these are certain protections guaranteed under Article 22 for punitive detention. Now, does all these extend to the preventive detention? That is basically the question here. Now, the first one, informing the ground of arrest, may or may not do. If the government feels that it endangers the security of the country, by informing that, okay, this is the ground of arrest, then they need not. Second, legal counsel. It is all again up to the state to provide legal counsel or not. Generally, it is provided, but they may not do it also. Third one, magistrate के पास 24 hours के अंदर लेके जाना है, that is not there. So time duration that is there is 90 days. 90 days तक you can actually keep that person without sending him to the magistrate for 90 days, and after 90 days also, if you need his custody, you can actually consult the advisory board. Advisory board will have the judge of a high court, so he will look into the case, he will look into the seriousness of the case, and if the judge feels that this person needs to be detained for more than 90 days also, because certain aspects of that crime is not very clear and the government wants to do further investigation into it, for that custody would be required. So the advisory board can extend it even beyond 90 days also. So then he has to be released, that is not there. So here let us come back to this question. The Constitution of India exempts the state from providing legal counsel to a person being held on preventive detention. Here the term to be considered here is exempts. Exempts means compulsory, saying that it's not needed at all. So does it say that? No. What does the Constitution say? Constitution says that it is up to the state, it is up to the government, saying that if the government feels that by giving legal counsel it's going to become dangerous or he is going to endanger security of the state, then they need not. So it's not exemption, it is optional. It is discretion of the state. So we cannot use the term exempt here, which becomes a very far-fetched statement. So second statement here is wrong. So we need to eliminate the far-fetched statements. Please understand here the trick that lies here is any statement that you feel it is too far-fetched, you can actually eliminate it. Sometimes we know these things, sometimes we may not know these things, but these are very far-fetched statements saying that it is exempt. The state need not provide counsel. That's not a great statement to make. Okay. So on the face of it, it looks to be wrong. Okay. So second one is wrong. According to the Prevention of Terrorism Act, that is POTA, confession of the accused before the police cannot be used as an evidence. So if you see in general, can the confession by the person in front of the police can be used as an evidence? It can be used as an evidence, but Article 20 also says that we cannot go for self-incrimination, or forced self-incrimination is not allowed. So it can be used as an evidence, but once the person is actually produced before the court will ask him whether that statement that is made by him has been made under any threat or force. If he says that it is under force, then that evidence gets retracted. Okay, so that is not considered as an evidence. If he also says that, yes, I would want to agree, saying that I have done the crime, that is self-incrimination, but it is not forceful. In that case, it is considered as an evidence. Now, can the court declare a person guilty on the basis of this evidence itself? No. The court will consider this as one of the evidences, but these are supporting evidences. It is on the prosecution to prove that the person has actually done the wrong thing or performed the crime by using other evidences. There can be digital evidences, there can be people evidences, etc. So these are things which can be used as circumstantial evidences, supporting evidences, but other evidences are required for prosecuting that person. So is it allowed under the POTA? Yes. Why was the POTA opposed? Why was the POTA repealed? Because it said it went against the fundamental rights given by the Constitution of this country. The Article 20 says that, what does it say? No self-incrimination. But what does the POTA say? You can self-incriminate yourself. So under the pressure to actually close the case. The police may get somebody who is innocent, beat him up and ask him to confess a crime. And under that pressure, when he confesses that crime, that is given as an evidence to the court. Now, under the POTA, that was actually allowed. So, that is the reason POTA was actually struck down. So, no POTA, no TADA today. Okay. So, it is the confession of the accused before the police cannot be used as an evidence. It can be used as an evidence under the POTA. So, third one is also wrong. So, this is quite an interesting question. It goes far deeper than the constitution itself. It links article number 20, it links article number 22, it links your Prevention of Terrorism Act 2002. So, three things that you need to learn here. Okay. So, statement only one is correct. They have asked which of the following are correct. So, answer is only one. Okay. Are you guys enjoying this? Is it useful? Yes or no? Is that a useful class? Yes. Thank you. Next, consider the following statements in respect of the Constitutional Day. So, Constitutional Day was in news. Statement 1, Constitutional Day is celebrated on 26th November. Correct? Every year to promote constitutional values among citizens. Yes, because why 26th November? Because 26th November 1949 is when we adopt the Constitution of India. We accepted, we said that, okay, we are going to accept this as the Constitution of India. On 26th November 1949, the Constituent Assembly of India set up a drafting committee under the chairmanship of Dr. B.R. Ambedkar to prepare a draft Constitution of India. Did we do that? No. The drafting committee existed between 1946 to 1949 for almost 2 years, 11 months, that is almost for 3 years, and then drafted the Constitution of India. So UPSC sometimes gives this crazy easy questions. Now, obviously, even a school student would know that Dr. Ambedkar was the chairman of the drafting committee, but he was a chairman from 1946 to 49, and it did not start on the 26th November 1949. So, statement 2 is definitely wrong. Statement 1 is actually correct. So, statement 1 is correct and statement 2 is definitely incorrect. Okay. This is the C. This is one of the very easy questions that is there in this year prelims. This is the 2023 paper. Okay. So, 2023 ka paper was very balanced. The other questions in the paper were very tough, other subjects ka. Polity more or less very balanced. So we can say that around 3 to 4 questions were tricky. Some options were tricky. Other than that, this paper was like right on the UPSC lines. 2 to 3 questions ka confusion hai, no doubt about it, but that is not the basis on which you judge the whole paper. 8 to 9 questions have been good enough. Okay. So fair enough also. Fine. So we will stop here, and in the next session, I'll take up the 2022 paper. Don't go anywhere. We'll just start in a while. Just give me a 5-10 minutes break. Okay. Thank you.